Thank you all very much. I'm glad to be with you. I appreciate the invitation for a subject that I feel very strongly about, and I'm glad you folks are here for the very same reason. It's an important and timely summit that you're having, and of course I like to thank the people that are responsible for, like the Charles Koch Institute and the Foundation, for bringing us all together. I want to tell you how I became involved in criminal justice reform, why this is a very urgent issue for our country, as you know it is, and why it's an issue that deserves the support of conservatives. I was elected to the Senate in 1980. It was clear the United States was facing serious drug crisis at that time, and a growing crisis. Illicit drug use was on the rise. Narcotic trafficking reached unprecedented levels. Violent crime rates went up. Crack cocaine epidemic was a plague. In response then, Congress enacted a number of bills that form the basic framework of our drug enforcement laws today: the Sentencing Reform Act and the Anti-Drug Abuse Act. These laws, which passed with significant bipartisan support, put into place mandatory minimum penalties for drug trafficking offenses. Mandatory minimum sentences were intended to apply to mid to upper level drug traffickers. These sentences varied according to the quantity of drugs sold and the form of drug. Crack cocaine, for example, as you know, was punished more harshly than cocaine in powder form. During that period, Congress also passed legislation that created and then enhanced mandatory minimums for carrying or using firearms during the commission of a crime. Congress also substantially enhanced the application of a 15-year mandatory minimum penalty to career criminals convicted of firearm possession offenses who had been convicted for 3 violent felonies or serious drug offenses. I supported these efforts when they were enacted, and ever since I have consistently voted to be supportive of law enforcement efforts to fight crime, especially drug trafficking and violent crime. But if there is one thing that I have learned in my long career as a legislator, it is that it makes sense to revisit and oversee legislative programs. We have a duty to make sure that the policies we enact into law are having the intended consequences and are functioning optimally. In my view, mandatory minimums continue to play a helpful role. They can be an effective deterrent to criminal conduct, and they also are an important tool for law enforcement, prosecutors using them to encourage criminal defendants to accept plea deals and to help law enforcement go after drug kingpins. Mandatory minimums also promote uniformity in sentencing. They also help make sure that criminals receive similar offenses for their crimes, no matter what part of the country they are in and what judge is assigned to their case. But, and very important but, mandatory minimums also come with significant cost, especially when they result in long criminal sentences. Surveys have shown that most federal judges believe that mandatory minimums are too severe in some instances. Many judges are frustrated that they are not better able to take individual circumstances into account before sentencing. And some believe that mandatory minimums give too much discretion to prosecutors and not enough to judges. The increases in mandatory minimums have also resulted in a stiff criminal sentences and a boom to prison population. Going back to when I was first elected, 1980, 25,000 people in federal prisons. Today, 185,000 under the Bureau of Prisons. That means that in a period of time where the U.S. population has grown by approximately 43%, the number of federal prisoners grew by 650%. There are a number of reasons for this drastic increase in federal prisoners. There are many more federal crimes on the books. Also, it is clear that stiff mandatory minimum penalties have played a key role in the booming population there in prison. In its proposed budget for the coming fiscal year, the Department of Justice requested $27 billion, of which $7 billion, or roughly 25% of the total budget at DOJ, will go to fund Bureau of Prisons. Clearly, long prison sentences come with significant costs. In addition to the cost borne by taxpayers, there's also a cost to families and communities. In many cases, the severity of the crime justifies these costs, but that obviously is always not the case. In our country, the vast majority of incarcerated U.S. drug offenders are in state prisons. But after many years of increasing criminal penalties and building new prisons, a number of states, including Texas and Kentucky, and you may know other states, have shown that it is possible to reduce crime, incarceration rates, and recidivism while reducing the amount of time that offenders spend in prison. Texas, in fact, has closed 8 prisons while lowering its crime and incarceration rates. On the federal level, several attempts at sentencing reform have been made in recent years. Some have proposed entirely eliminating mandatory minimums or cutting them back severely. I have opposed such efforts. It is also clear that all too often, nonviolent and relatively low-level criminal offenders are dealt sentences that keep them in prison for longer than is necessary to punish them for their misdeeds. Such sentences are unfair and not very cost-effective, and they divert resources that are needed elsewhere to fight crime. To the surprise of some, one of the leaders in this area in recent years was my good friend and colleague Jeff Sessions. Working closely with Senator Durbin, then Senator Sessions co-sponsored the Fair Sentencing Act 2010. This act marked the first time in 40 years that Congress eliminated a mandatory minimum sentence. It struck the 5-year mandatory minimum sentence for a single possession of 5 grams of crack cocaine. It also increased the amount of crack cocaine that would trigger 5- and 10-year mandatory minimum sentences, thus reducing the disparity between sentences imposed for comparable amounts of crack and powder cocaine. More recently, a bipartisan group of senators, and I'm part of that bipartisan group of senators, set out to re-examine the drug sentences at the federal level. What resulted was a truly bipartisan effort to tackle a serious policy challenge. Senators brought a variety of perspectives and proposals to the negotiating table, but shared the same goal of promoting fairness in the sentencing regime. After many months of negotiating, we reached an agreement on a compromise bill entitled the Sentencing Reform and Correction Act. And while no senator would have drafted the bill precisely the way that one was drafted, the bill gained more bipartisan support and greater support from outside groups. The Sentencing Reform and Corrections Act gives judges more discretion over sentencing while preserving mandatory minimums as an effective law enforcement tool. The bill expands the safety valve for people who had not been convicted of violent felonies. It cut mandatory minimum sentences for other drug crimes, again, taking circumstances into account. It applies retroactively the earlier reduction in the sentencing disparity between crack and powder cocaine in the Fair Sentencing Act. And it makes various other reforms to sentencing, including allowing sentences to be expunged in certain circumstances involving young first-time nonviolent offenders. It also creates an alternative to the unconstitutional federal sentencing laws that permits juveniles to receive life sentences without parole. Finally, the bill establishes back-end sentencing reform in what is called the Corrections Act. That part of the bill would enable some prisoners to serve less time if they successfully completed programs that have proven to reduce the likelihood that they would commit additional crimes upon their release. The goal is not only to save money by housing fewer prisoners, but to reduce costs to society by reducing the chances that people released from prison will reoffend. Last Congress, this bill I just described to you came out of my committee by a 15-5 vote. Had the bill reached the floor, it would have passed overwhelmingly. And most of you heard Senator Lee say the same thing this morning. And I agree with what Senator Lee said, and I still think it has that kind of support yet. The House Judiciary Committee passed a series of bills, but in a presidential election year, no sentencing bill reached the House floor. We continue to negotiate following the Judiciary Committee's vote, working with any senator and outside groups that express flexibility in supporting the bill if we made changes. We made changes to the bill's original provisions concerning the misnamed Armed Career Criminal Act. We also made adjustments to the use of funds saved by the bill and created a national commission to review the criminal code. The changes that we incorporated have kept the package balanced and kept the bipartisan group unified. But it must remain that way if it is to advance through this Congress. So on October the 4th, Durbin and I reintroduced the Sentencing Reform and Correction Act. The bill has already garnered significant bipartisan support. We have expressed our desire to work closely with the White House and the Justice Department to make criminal sentencing of nonviolent offenders more fair. In doing so, our goal is to reduce recidivism, combat crime, and make our justice system more cost-effective. We know there are some in the administration who are strong supporters of the bill. There are others who are skeptical of parts of the bill, but we will continue to engage those people. I appreciate the attitude of Attorney General Sessions, who recently testified at my Judiciary Committee hearing that he was willing to work with us on sentencing reform. It is consistent to be tough on crime and still support sentencing reform. We will work with the administration, with law enforcement at all levels, and with outside groups to address your outstanding concerns. Those stakeholders who approach us prepared to engage in productive discussions and to negotiate reasonable compromises will find us willing partners. We can maintain a balanced approach in these conversations that can expand support for the bill and will make needed reforms to the criminal justice system at the same time. In addition to giving judges more discretion over sentencing and reducing recidivism, one advantage of that act is that it frees up taxpayers' dollars to focus on other important priorities in the criminal justice system. One area where these resources could be effectively deployed is something the President declared a national health emergency today, the opiate crisis. President Trump's Commission on Combating Drug Addiction and Opioid Crisis has already made some valuable policy recommendations to our bipartisan group. I salute the President's leadership in this area to address the opioid crisis. To tackle the opioid crisis and to continue our fight against drug trafficking and violent crime, we need to focus our resources on the most serious offenders. The Sentencing Reform and Correction Act frees up federal resources to more effectively fight crime, and it gives prisoners a fair chance to reform and re-enter society without sliding back into criminal activity. By reducing crime and freeing up resources, this legislation will work effectively with other legislative initiatives like the Comprehensive Addiction Recovery and the Stop the Importation of Synthetic Analog laws and bills that are in, to aid law enforcement efforts to keep our communities safe and to reduce drug trafficking and violent crime. Before I say thank you once again, I hope that any of you in this room that have some suggestions or concerns about this legislation will feel free to contact me or the other main co-sponsor, Senator Durbin, a truly bipartisan bill, to see what we can do to help move this bill along. Thank you all very much.